including pharma companies, universities, medical research companies, and software companies. His educational background is he holds a BCom from Bharat Mata College with a gold medal, and he has an LLB from School of Legal Studies, Cochin University of Science and Technology, and has got a third rank, has secured a third rank, and he holds an LLM in IPR from SLS Cochin University. There also he is a gold medalist. Was the recipient of a national level scholarship awarded by Ministry of Commerce, Government of India for pursuing IPR at LLM level. He has a lot of honors and achievements to his name. Was a resource person for training program for High Court judges conducted by Kerala Judicial Academy. He was the youngest person to be nominated to the advisory panel on IPR of Kerala State Council for Science and Environment. He is an executive member of Indian Council of Arbitration Kerala chapter. He's also got published a book on study on test data protection in India, published by Eastern Book Company, and has published various articles on legal journals, magazines, and dailies. He's also a faculty, and he's a visiting faculty on IPR Newell's Cochin, and has been a resource person. Newell's is National University of Advanced Legal Studies, and has been a resource person for various training programs. So I welcome you, sir, to this program wholeheartedly, and thank you for accepting our invitation. I'll request you to take over from here, sir.
Thank you. Thank you, Dr. Ravish. Thank you very much.
Thank you. Thank you.
Yeah, very good morning to you all. I'm really happy and really privileged to get an opportunity to interact with you. As you all know that intellectual property rights, differing from the other laws area of law, it is really requires an interdisciplinary approach towards complete understanding and effective enforcement of the law, actually. So I'm really appreciate the Inter-University Center for IPR Studies for organizing such a program, which gives a platform for discussing, all aspects of IP with regard to the management, and from all different walks of life connecting with IP, research scholars, academicians, scientists, lawyers, as well as research professors in the field of law itself. So the topic which is given to me is with regard to the enforcement of intellectual property rights. Most important aspect is that if you have a right to legally speak, that when you have a right and which cannot be enforced, there is no meaning for that right. So particularly when you talk about intellectual property rights, it is a special type of right. Now, I just wanted to show you how do you might have gone through the different aspect of intellectual property, but the basic thing actually you can go like this to show like this actually, because there are two persons or two insights involved in intellectual property. When you talk about what is intellectual property, as I have shown in the presentation, one is a person called creator. That creator can be a scientist, as you all know, that it can be a scientist or a writer or a company which does a new invention, a new design, whatever it may be. They are all called creators. The creator transfers the intellectual labor to the society, and society in return, please click, can you just click on that? Vijita, can you just click one more? Yeah, thanks. Yeah, so what, no, that is going back. Yeah, just to say that, yeah, thanks. So this is actually the concept which we try to understand from the legal regime of what is a right actually. Because from this actually we try to understand how we can enforce, because which we create a transfer the intellectual labor in the form of a story, or in the form of an invention, or in the form of a new design, or in the form of a trademark, or a new variety of plant variety, or in the form of a GI. We transfer it to the society, and the society grants back a property right. That is the most important aspect, because unless a society grants in the form of a property right, you cannot enforce that. So we adopt that as a property and identify that, and creative work is it is a very connected property rights of a creator. So you can enforce that. So that is the aspect wherein which, unless you are not able to enforce this right, whole rights given in the papers are not able to, that becomes absolutely useless actually, because we have if you look into the different international conventions, human rights, exactly, those kinds of rights which cannot be directly enforced because they are remain on the international norms. So once, in order to incorporate that, right, we have recognized, as you all might have studied in the last sessions, trade-related aspects of intellectual property rights, commonly known its acronym TRIPS agreement, has really opened and widened the scope of intellectual property rights in the international scenario. And it was made all the member countries to make changes in its IPR laws. So as we are know that just we are looking into the it is intellectual property. One of the different things with intellectual property with other rights is that it has a all the right has to be encapsulated in statutes. So you need to look into other statutes at all. If you have a copyright, you need to look into the Copyright Act to understand what are the rights available, what are the remedies available, etc. So we'll just go to the next presentation to see what are the how does the Indian Acts govern that, please. So this is, I know that we have covered just to give a brief introduction of, we have a Copyright Act 1957. As you know that copyright is a bundle of exclusive rights given to an author of a literary, dramatic, musical, artistic work, cinematograph films and sound recordings. Know that there are section 14 enumerates a lot of rights with regard to right of reproduction, distribution, right to make a cinematograph film, right of right to musical composing, everything, different rights are being provided for that. So all these rights are being recognized under the Copyright Act. And the Trademarks Act, as you know, that trademark is any kind of mark or a symbol which you use to identify the origin of a product or service which is being offered. So you all know that must have a distinctiveness, and in order to identify as a trademark, so that is very important. So once it is being trademark is registered, the registered person gets certain rights which is being provided in the section 28 of the Trademarks Act. In the same manner, Patents Act. Patents Act is governing with regard to inventions, as you all know that any inventions which is new, having an inventive step and with an industrial application is protected under the Indian Patents Act, subject to the limitations as is provided under section 3 of the Patents Act. So these patents also, when this patented product has been provided under section 48 of the Patents Act, a patent is being granted to a person, he is having the exclusive right to manufacture, export, import, offer for sale, and connected all these aspects is given to that particular person. As you all know that patent is the most strongest form of monopoly across all intellectual property rights. That is why we have all, whenever this discussions comes with regard to the patents, it have a long impact on the developed and developing countries, the pharmaceutical companies and the user people. All these aspects we have, India has come across a lot of cases with regard to the compulsory licensing of patents, the cancer drugs, the evergreening of patents. That is because it directly affects the people and their life, because if nobody should be allowed to use the patent in a very arbitrary and abusing the monopoly power of the Patent Act. So that is one aspect. And Designs Act is, we talk about any kind of ornamentation which you apply on an article is a design. And as you all know that Designs Act 2000 in India governs the designs, and it provides that a design has to be registered in order to be protected. It grants a protection for a period of 15 years. And design also, when try to imitate that design. For example, if you have a lot of designs being registered nowadays, the biscuits design, how do you appear, any kind of ornamentation which you, perfume bottle design, a window, a car, all these skills comes within the purview of Designs Act. So any kind of ornamentation. So when other person try to imitate that design, it happens that the violation of the rights happens. And also Protection of Plant Varieties and Farmers' Rights Act 2001. That is also a protection under Indian law given to the new varieties of plants, varieties that is being granted the protection of plant varieties, new varieties of plant varieties. So what happened is that it just need to be said that no, it has become 2001. India is the first country to balance the protection of plant varieties along with the traditional farmers, recognizing their rights and also some kind of exception to them. So that need to be said, because that need to be known, even though it has happened in 2001, the process At that time, what was in a major issue at that time. Here also, when one person has already been secured a protection for new varieties of plants, another person is using or resowing it, or in that manner that is right is being affected. So that is also can be infringement can be taking place. And geographical indications, as all know that any product or its character or trait is attributed to the geographical place or origin of that product or character. It we call it as geographical GI. It's commonly known as. Fortunately, taking into consideration the cultural diversity of India, we have a lot of GI has been registered. I think GI registry is very active, and we have a lot of GIs: Kanjipuram sari, Banaras sari, different in turmerics, lot of in pharmaceutical, I mean, sorry, farmer products, as well as other segments also. There are a lot of GIs has been registered. Food segment, farmer segment, clothing segment, all these kind of lot of GIs has been registered. So that is also when other person is not having from that community. For example, if I do not have a connection with the Kanjipuram, but I try to sell as Kanjipuram saris here in Kerala without any kind of connection or without any link with that society who is having the protection under the GIs Act, it is an infringement. So it is we need to our rights, the original community whose rights has been vested under the Act is being violated, and he can seek for an enforcement. And the other one is that is a comparatively small one, and also the application is much lesser. The Semiconductor Integrated Circuit Layout Designs Act, that is commonly be known as NP diode, which we all study. The technical person know much about it. Yeah. So that is also being protected, and the protection is given to 10 years, right? I'm seeing the questions which is being coming in. I will be answering in the final week after protection. Otherwise, I will be answering that questions. Okay. And when we say that it is an infringement, normally infringement, as I said earlier, we divide the infringement into two categories. That is, when you directly violate the rights provided under the statute, we say that primary infringement action. For example, if you have a copyright, or as you copyright, when you have written a script or you have written a story without your permission, I am just reproducing that without your permission, or I am converting into a movie without your permission, that is a direct violation of Section 14 of the Copyright Act. That will be held as a primary infringement. In the same manner, when infringement trademarks, I am copying another person's trademark, or I am, for example, I am selling certain products under the trademark Pepsi or Coca-Cola or any other registered trademarks or which are popular. So that is also just violation of trademarks, and the trademark right is being violated. So that can be called as a primary infringement. When you call a secondary infringement, what we intend is that you be a secondary role. For example, I am providing a space, a cinema theater, for showcasing, or showing the pirated versions of the movies, or I am selling my shop in which I am selling the pirated copies of the books, or I am selling pirated or these duplicate products which are not genuine under the trademarks. If there are, that certain streets in India, if you go to different, particularly Indian places, there are, that there are slots in India where in which we can say that we get all the branded products which are not, even purchasers know that they are not original. But they call it the spaces, or we are providing those who person providing the space we call them as secondary infringement. Okay, so that is the infringement part. So what I'm trying to say that initially you have a recognized rights under the different statutes, and when these rights are being violated, we call it as infringement. Okay, so infringement comes, and then we have what is the remedy. For example, my book is being copied and my book is being published, or your book is being converted into a movie without your permission, or your trademark is being pirated by another person or duplicated by another person. Your design is being duplicated by another person. So unless there is a remedy, we don't have any other. There is no meaning in saying that it is a right. In order to call it as a right, there must be a remedy for the violation or the infringement of the right. Okay. So can I just go to the next presentation, Vijita? Yes. So normally, yes, thanks. So under the infringement aspect, we divide because it is not due to the paucity of time. It is not possible to go to individual statutes and say what are the remedies available. We have almost, so we have what did we, it was, what we have, divided the remedies available under different statutes into three, basically. One is called civil remedies. For the non-legal persons, we can say that, for example, if you symbol as a intellectual property is like any other property. So, if you have a 10 cents of land, imagine that one person is trying to encroach into 10 cents of land, or without your permission, he is encroaching or constructing some building in your 10 cents of land. What is a civil remedy is that you have to go to the civil court and get a relief under the civil court. For example, civil court in the meaning we say that it is a municipal court or the district court or the sub court, in that manner actually. We call it a civil law because we do not have a criminal character, criminal type of remedy available. But that is civil remedies. But in the intellectual property, it is very important to know that when your rights are violated, you also have the right to seek a criminal remedy also. Because, for example, there are your books or your movies being pirated, and a lot of CDs has been sold in one place. So you have a criminal remedy available under the Copyright Act to approach the sub-inspector of police towards search and seizure, and it is criminal liability is also amounting to that on that particular infringement action. So that is very important. And then we have an administrative remedies. Administrative remedies, what we call it as an administrative remedy in the sense that in the statutory regime itself, for example, you are the owner of a particular work. You have written a story or you have written a script. You are the owner of a particular work and you are the original author of the work. Without your permission, other person got registered under the Copyright Act. So you have a right to get it cancelled before the Copyright Board, because it is not, you are not the original, the person who got it registered is not the original author of the work. In the same manner also, the Patents Act also, there are a lot of administrative remedies available. For example, you are a patentee or you are the person of, you are a patentee of an invention, and you see that another person has filed an application for patent with regard to the same invention, and it is being published in the patent journal. You have a right to oppose that patent application under Section 25 of the Patents Act. And not only that, even if the patent is being granted, you have a right under Section 64 of the Patents Act to revoke the patent on the grounds provided in the under Section 25 along with Section 64 of the Patents Act. So what are the mainly grounds? You might have gone, it is interesting to know that, because if the mainly grounds revolves around the criteria of granting a patent is not being satisfied. For example, already if the patent is being patented, the other person cannot get a patent on that. So it do not satisfy the novelty, it do not satisfy the inventive step, or it do not satisfy the industrial applicability. In other grounds also, it is already being, it does not satisfy the Section 3 criteria. Section 3 criteria prohibits a lot of, for example, traditional knowledge inventions, the evergreening of patents. All these things are being violated and the patent has been applied. You have a right to oppose. That is provided to the administrative remedies. So in order to seek the administrative remedy, one important aspect you have to see that it may not be necessary that you should be an owner of the patent in that scenario. For example, even if you are seeing that a technical application which is very common in the industry is one person has filed for a patent with regard to the technical application. Any person interested can file an application for opposition of that particular patent. So in the same manner, this trademarks also we can challenge. This particular mark is being published in the trademark journal. Anybody, if I feel that I have a trademark or I have a registered trademark or I've been using a trademark for a long period, then actually one advantage is that if that other person is applied for a similar trademark and that is being published in the trademark journal, I can oppose that trademark. saying that this it is already being deceptively similar to the mark already being registered, or I have got a much broader reputation, I am the prior user of that trademark. So all these grounds, based on that, I can oppose that trademark claim. The same manner, all the systems, for example, geographical indications, semiconductor chip designs, everywhere there are administrative remedies wherein which the mechanism to get the monopoly or is being trying to abuse. What I was trying to say that all intellectual property, we know that it is one way of regulated monopoly granted to the owners actually. So the monopoly, before granting, it should ensure that the particular the purpose is being achieved. That is the most important aspect. When you grant a patent, we should achieve that the patent is being granted for novel inventions. It should not be granted for an already existing invention. There will be no purpose will be served. The same manner, when you grant a trademark, the trademark must be distinctive and is likely to, it should not cause any much confusion. When you give a two type of registration protection to two similar trademarks, that be giving confusion to the market, and that be failing in the whole purpose of the Trademarks Act itself. So that is not intended. What we intend is that the particular thing, when you grant the monopoly itself, the monopoly must be regulated and must be there. And so these are the mainly, we classify the remedies under civil remedies, criminal remedies, and administrative remedies. Please, next presentations. Yeah. So what is a civil remedy actually? That is very, very important. As I rightly said, coming into the intellectual property rights, just as that is why in the beginning itself I said, intellectual property is a type of property which is being recognized by the statute. And your right is being violated. And in the right, when it's being violated, your statute provides a remedy under the civil law, along with it, as well as the criminal law itself. So in the civil law, we have all the applications. For example, as I said, when you have a 10 cents of land and your land is being encroached by other person, you can approach the municipal court or the district court or the sub court, and you can seek remedies. In the same manner, you have this civil remedies available to a intellectual property owner. That is mainly what is the remedies which we seek. For example, when you have a, mainly we seek before one of the main remedies which we seek is a permanent injunction. What is an injunction? Injunction is an order of the court to stop the infringement action. For example, one person is actually going to make a movie based on a story written by me actually. I have a right to approach the court and say that immediately the steps making a movie based on my book without my permission should be stopped. That we injunct means to stop. That is why. So we have an injunction of two types actually. One is temporary injunction and the other one is permanent injunction. What we're trying to say by temporary injunction is that particularly when you take into consideration of intellectual property, as you know that all our normally civil disputes take comparatively longer time to get a finalization. If in the case of if your story is being infringed by other person and is being made into a movie and you want an immediate injunction, there is no purpose in after the whole movie is being made and whole movie is being telecasted. If something an order is being granted to you, there will be no purpose served to you. So that is why we always, the IP lawyers always concentrate on temporary injunction more rather than the permanent injunction. The difference, I just let you know how the procedure starts actually. When you file a case saying that, imagine that I have a case that my story is being made into a movie without my permission. I approach the court alleging all these aspects. I file a complaint before the district court and I say that my story is being copied by the other person and made into a cinematograph film in violation of section 14 of the Copyright Act, and that need to be stopped at the earliest. and I file a petition for interim injunction along with the main complaint. And I pray that interim injunction be granted at the earliest. Why? Because if the interim injunction is not granted at the earliest and is moved to the finality to the other last final disposal of the case, my whole purpose will not be defeated. So that is why I moved for a temporary injunction. We call it as a temporary injunction. Okay. Then the question comes, what are the criteria considered by the court while granting temporary injunction? For example, you have a case. I am trying to approach the court, as I said. Court considers mainly 3 points. One is whether there is a prima facie case. Second one is whether there is a irreparable injury is going to be caused. Third one is whether there is a balance of convenience in favor of the person approaching the court. I'll just explain. Prima facie case, in order to prove my prima facie case with regard to the copyright matter, I can say that if I should be able to prove before the court that I am the author of the particular script or story written by me. So in order to show that material, I should produce material before the court. Something, for example, the work is being published in any magazines, or some people so that I already been copyright can be registered. So registration certificate, all these can show that I am the owner or author of the copyright of the particular story is being written. And secondly, you can show that how does, for example, any writer based on the movie has been already released, and it shows that some kind of similarity has been with the particular work of you and the film going to be made. So you can convince the court that how far there is a similarity with regard to that. So there is a strong prima facie case with regard to that. Or in other situations happens like this. For example, you are the author of the work, and for example, you are a friend or somebody who are associated with your work, and he's going to make a movie. So there is a connection. How does that material has been to the other person? That also can enable to prove a prima facie case before the court. And what is the irreparable injury is the court has to make a consideration of the 2 cases. Who is going to cause an irreparable injury if the injunction is being not granted or injunction is granted? For example, as far as I am concerned, if the film is being made, allowed to make, and which is permitted to release without identification or without giving me any royalty, that is absolute violation of my right. And there will be irreparable injury will be caused to me. Okay. And the court will consider the balance of convenience. The court has to consider the balance of convenience also. For example, in this case, the example which I said, other situations may happen. For example, the movie is already has been made and it's on the verge of release. And on the verge of release, I'm coming to the court and saying that no, it is my work and you have to stop the release. So the court will make a balance whether after this much money has been spent on this particular movie, and if not being released, the injury cost to the particular movie producer will be more than the original order. So court will make that is the 3 tests I said. One is the prima facie case. Second one is the irreparable injury is going to be and the balance of convenience. All these 3 points which need to be considered while granting a temporary injunction. And after this, then we move towards the trial, and the court requires into all details, and finally court grants you a permanent injunction actually. So that is the first, normally in all IP matters, the most important remedy which we seek is the temporary injunction as well as the permanent injunction in the final. Okay. The second is that we seek for damages and damages or accounts of profit. Damages is a compensatory relief which given to us for the injury caused by the infringement action. So damages can be of different damages, and penal damages can be, or compensatory damages can be fixed. So that is, as far as if we look into the damages system in the US, and if you look into the system, damages provided by in Delhi or small towns like in Kerala, we can understand the difference, because the damages are more particular thing in more in metros, I mean courts, because they look into the volume. Here, as far as the damages are given comparatively low, but that need to be changed, because when you grant, unless the penal damages only can, I mean, is granted, then only the value of IP can be protected more effectively. And for example, if some kind of the author does not want to damage, the author can prefer for an accounts of profit. Accounts of profit is something which is actually one of the advantages of accounts of profit is that I want a share, or I want the accounts profit of the I want a share of the profit which has been made by the infringement activity carried out by the infringer. So that is one important point you should keep in mind is that you cannot seek damages as well as accounts of profit. It is not possible. Either you can seek damages or you can seek an accounts of profit. That is important aspect. Then you can have a seizure of infringing material. That is also there when the material is being infringed. Sometime at the interim level itself, you can get a seizure order when the infringement is prima facie very clear. We know that by duplicating of the branded products, all these things are very clear. The court can grant easily an interim order of seizure or the final order after disposal of the other things. The court can grant a seizure of the infringing material also can be granted with regard to that. Okay, so then can I just move the next presentation? Yeah, one important aspect when we compare with the other civil law, I just want to highlight that also. Normal other civil laws, the original jurisdiction or the first court which we approach is the Municipal Court. But in the case of IP matters, we have a Copyright Act, Trademarks Act, Designs Act, etc. The original jurisdiction comes to the District Court. That is on a higher pedestal, taking into consideration the complexity of the matter. The lawmakers has given the jurisdiction to the District Court. In the primary jurisdiction of the cases relating to intellectual property rights originally goes to the District Court. That is a very important point, because you cannot, some people actually, without knowing that, even if in the case of, for example, I just want to make a differentiation with regard to the Trademarks Act. Trademarks Act, actually you have a two remedies. One, we have, when you discuss about Trademark Act, one is under the Trademarks Act itself. That is, you have a special section 28 and all these section 27, all these sections which talks about what amounts to infringement and what are the remedies available, and other sections also. But apart from the statutory remedy, with regard to the trademark, you have a common law remedy under the term passing off. Common law remedy, what I want, but particularly without the coming from the non-legal background, I just want to explain that. Common law remedy is a remedy which is being, which don't have a statutory base, but which has been developed by the courts from time to time. That is developed in UK. And passing off under the principle of passing off, it is an equitable remedy. That is where the justice must be rendered. That is a principle. And passing off, what we are trying to understand is you should not pass off your goods as that of the another. Or when we try to say that you should not misrepresent your goods as that of another. That is a passing off principle. So when the passing off comes, even though under not the Trademarks Act, not under the Trademark Act, but you have a remedy to approach the court. There was a disparity. People come and say whether it is a common law remedy, can I go to the municipal court or can I go to the district court? But the Trademarks Act itself make it clear that even in the case of passing off also, you have to go to the district court of the original jurisdiction for filing a case under the Trademarks Act actually. And another important aspect that is very important with regard to the facilitative jurisdiction, the Copyright Act and the Trademarks Act provide a very special protective provision in respect of authors and the registered trademark proprietors. What I mean by registered trademark proprietors is that those who are already registered, getting registered under the Trademarks Act 1999. What is the advantage? In order to know the advantage, you should know what is a normal provision. In a normal provision, for example, if I wanted to file a case against a person in Delhi, I can file it only in Delhi or any other place where the cause of action was aroused. For example, then only I can file a case where only. But with regard to the Copyright Act, Section 62 of the Copyright Act, as well as Section 104 of the Trademarks Act, which provides a protective provision wherein which I can file where I am residing or carrying on business. For example, in copyright, I am relating to copyright because it is easily understandable legal terms. I have written a book. I am in Kerala, and one movie is being made in Bombay. I can, if I want to, I feel that that movie is a copy of my book. I can file a case in Kerala, or I can file a case in Kochi, where which I am residing or carrying on my business. That is a very protective provision which is made available to authors under the Copyright Act. In the same manner, the Trademarks Act also, if the mark is registered, I am entitled to that benefit of protective provision under the Trademarks Act also. What I say that my mark is registered, and I feel that my mark is being duplicated, or deceptively similar mark is being used in Delhi or in Bombay, I can file a case here and I can serve an injunction order there in Bombay or Delhi. So there are a lot of instances happened where in which in Bombay from you can find, and normally big companies duplications happens in small places. The orders, if the case is being filed in Delhi or Bombay, or the next against a person in Kerala or some other small places where the infringement action takes place. So these very important portions you have to understand, because that is a departure from the normal jurisdictional section of Section 20 of the Civil Procedure Code, where in which only you can file a case in which where the defendant resides or carries on business, but and cause of action arises. But here, where you are the author or you are a registered proprietor, you can file a case where you are residing or carries on business. That is a major departure, and that is a very good provision as well as the protection of intellectual property rights are concerned. Please, next. Can you just, yeah. When we talk about, as I said, the criminal remedies, that is, I said, no. When you talk about criminal remedies has to be stipulated in a particular individual statutes as it is. For example, the copyright law, I'm just referring to copyright as an example because copyright provides a very wide provision with regard to the criminal remedies actually. That is, anybody knowingly infringes, as you all know that particularly with regard to the non-legal persons, I just wanted to say one of the important aspects of the criminal law is a mental element. You should either you have a knowledge or you should have a mens rea. You should have a knowledge or intention to do that. That is why. So when he knowingly infringes or abets the infringement of a copyright, normally that takes place with regard to the, as far as here nowadays, earlier with regard to the duplication of movies and CDs, people or original movies, now even know that the online piracy of movies all takes place. That all can be under the criminal remedy. That is, you can seek a criminal remedy. How do you seek that? And knowing use of an infringing copy of a computer program, a pirated version you are using, that is also the original honor of the pirated copyright honor of the version of the, for example, Microsoft or any other programs can come and sue, may not sue, take a criminal action against you for a pirated use. And the punishment from 6 months to 3 years. The punishment is up to 6 months to 3 years. Okay. So that is very important. That is making the copyright honors right more stronger, because why do we provide a criminal remedy is that when you provide a criminal remedy, the people who are infringing will have a deterrence effect. Either those who will try to withdraw or abstain from doing such an action. That is why normally we provide for a criminal remedy, because they know that they will be going behind the bars, and in that situation, so that will be more creating a social stigma as well as a civil remedy is concerned, and also it's comparatively faster. But in order to have these issues with regard to when you talk about criminal remedies with regard to the copyright, you need to show that you are the original author. That burden of proof will be more, particularly court is looking into that aspect. Otherwise, anybody, that provision can be abused also. In order to provide that certain decisions, I mean, by the high courts as provided that there will be a more serious looking into the aspect which is required when a criminal action is going to be initiated against the infringer action. And one aspect you should know that the imprisonment is up to a period of 3 months, 6 months to 3 years actually. So please go next. Vijita, can you just go to the next presentation? Yeah, earlier one. Yeah. And also we have we have also with regard to the possession of plates for making infringing copies. We are any kind of material which we use for infringing copies or using circumventive measures. Circumventive measures, what we do is that, as you all know, that the World Copyright Treaty, we are in the digital era. We have a circumventive, we have a measures or security measures which we incorporate in a particular software and all these things, which we try to use in a circumventive measures. That is also amounting to a criminal liability. And with regard to the electronics rights management information or tampering or electronics rights management information or any other mechanism wherein which the right is being violated, you are not a member of this member database, you don't have exclusive right to do that. Then when you try to try to violate that right, that also is entitled to a criminal remedy. And that is also the penalty is provided for imprisonment up to 2 years and a fine is being provided for that also. So that is right. And please go through the next one, next presentation. Yeah. One important aspect is that people take it very, very light actually, but the offenses alleged are not light as you see, because it is cognizable and non-bailable. Cognizable in the sense that any police officer, not below the rank of a sub-inspector, can come and arrest you without a warrant. It's like, so any other major offenses, if you are indulging in copyright violations, any person, any police officer not below the rank of sub-inspector of police can come and arrest you without a warrant. So that is a very one, and that is also to non-bailable. So in the police station, you cannot get a bail. You have to go to the court, and court has to grant a bail. So that is making it more deterrent and more stronger that you should not indulge in such kind of copyright violations, protecting the rights of the authors. And that's why the one important aspect with regard to the copyright, I don't know whether you have discussed or not, there is a confusion that copyright registration is not mandatory for claiming a right. That is why I just noted the point, because there is, some clients even come to us say that, sir, we didn't register our copyright, but we have an issue. Can you help me? So that is the question is that with regard to the copyright, the registration is not mandatory as per the Copyright Act. But one thing you should keep in mind is that Section 48 of the Copyright Act specifically provides that registration provides you a prima facie evidence of your ownership. Registration provides you a prima facie evidence of your ownership. So that is very important. Right? Why I say that? Why do I say that? Because when you file a case against another person, if you have a registration, the burden shifts to the other persons to prove that this is what. Normally, when we say that, it found to be easy, but in practical, it is very difficult. When I file that registration before the court, that this is my registered copyrighted work, and my work is being infringed by other person. Other person need to show that if we have make a claim that this is also written by him, other person need to show that either this work was written by him before that. So the burden is more than the normal thing. So that is why, even though we say that registration is not compulsory, But from a very practical legal angle, with my experience in the field of IP litigation, I say that registration provides a very important role in proving your right in a court of law. So that is why it's also very, very important with regard to that. Please. Vijita, can you just go to the next question? Yeah. That is why copyright also provides a very wide powers to this special power to seize infringing copies. That is also very important. Why do we say that infringing copies in the manner not below the rank of a sub-inspector? That any offense, section 63, that is, I say that any person infringes or knowingly infringes or abetting the infringement. Abetting means facilitating the infringement aspect. He has come to, I mean, any police officer wherein which, for example, a copyright material has been reproduced without any permission, or any pirated movie is being shown, or pirated CD is being multiplied, or any software wherein which it is being without use, without permission. So that all can be, I mean, not a police inspector, not below the rank of a sub-inspector, can go and seize and take immediate action against those infringers. That is right. That is very important. And without seize, without warrant, arrest, and infringing copies before the magistrate. That is special powers provided under the Copyright Act. These criminal remedies provide special powers under the Copyright Act as well. Vijita, can you just move to the next step? Yeah. Then we come to trademarks. As I said, no, trademarks is when you say that, as you know that selling the common parlance, when we say that we can see that a lot of duplicate products available across the globe. I mean, across small markets. That is a prima facie example of trademark. If I am selling some kind of non-products or registered trademark holders, right? I'm deceptively similar trademark I'm using. That is amounting to a trademark infringement actually. And one important aspect with regard to just explain for your purpose, earlier we had a Trade and Merchandise Marks Act 1958, wherein which the infringement was only helped when there is the deceptively similar marks are used in the same class of goods. For information, trademark rules provides around 45 classes of goods. For example, section 43 provides for these kind of education. 41 provides for education, entertainment, etc. So those kind of services, if any other person using a deceptively similar mark with regard to that type of services only, then the infringement can be held to be. I mean, you can say that there was an infringement. I'm just giving an example. But into the after coming into the Trade and Trademarks Act 1999, particularly incorporating under the provisions required under the TRIPS agreement, the Trademarks Act 1999 really widened the scope of infringement. That is very important because nowadays, I mean, what is happening in this? I just want to give an example in this. Nowadays, earlier, for example, if I'm using a trademark with regard to a chapel or a footwear, another person is using with regard to a footwear, then only I can, with using a deceptively similar mark, then only the infringement action can be held liable. But now, for example, there was one interesting case, not an interesting case, it has actually changed the whole scenario, with even though under the passing of that has been incorporated under the Trademarks Act 1999. What happened is that you all know, very familiar with the trademark Benz. Okay, the cars, the luxury car, the technically brilliant, the technology brilliant Benz. So we all know that Benz, what we hear about Benz, when you hear the Benz, we get a notion of technical brilliance, luxury, etc. What happened is that VIP launched an underwear under the name VIP Benz, and the Benz actually filed a case against VIP. So what the contention of the VIP was that it is totally in a different product, because Benz is in respect of cars, and VIP underwears in the case of innerwears. There is no connection, and the people are not going to be affected or misrepresented. There is no misrepresentation, and there is no passing off as alleged by the Benz companies. Okay, but there actually the court has adopted the principle of dilution of trademark, which originated in United States of America. What is dilution of trademarks is that, imagine that today you're permitting a person to use Benz in respect of underwears. Tomorrow, another person is using Benz in respect of toothbrushes. Day after tomorrow, another person is in respect of apparels or clothing. So after a period of 5 years or 10 years, in a group, if I ask you the question, what is the primary notion about Benz, if you hear that word? One person may say that it is a good underwear. Another person may say that it is a good brush. Another person may say that it is a good car. So the distinctive character, the getting affected, and it is being diluted. And the integrity of the trademark is being affected. So that was held under the principle of passing off. And what happened is that the principle of passing off has been now added into the statutory framework under the Trademarks Act 1999. So why I say that now the Trademarks Act 1999 is very wide, so that even if the product or services is totally unconnected, you can file an infringement action provided that the mark is deceptively similar and there is likely to cause confusion in the relevant section of the public. That is very important. That is a major change brought in by the Trademarks Act 1999. So even if my brand is my registered trademark, I've got a reputation, another person is using in respect of a totally deceptively similar product, but I feel that his use will affect it will amount to dilution of trademark and also affect my integrity, and there is likely to cause confusion in the market, saying that that same product is coming also from the same source. That is a good ground for infringement, and I can take an infringement action against them. The same manner, even a company name, corporate names nowadays, that is also, earlier it was all covered under the passing off. You can say that there are a lot Mahindra and Mahindra case as well as said in the Supreme Court. Say that it is, I mean, one person has got a much reputation in that field, other person operating in totally different segment. But the Supreme Court had said that it is not like that. Even though the intention is, I mean, when other person has got a more reputed and has prior use earlier, and there may be a cause of confusion, and that will be detrimentally affecting the original person who started the trademark and started using it. So even the company name, we say that trade names, that also can be, I mean, any person can be prevented. For example, if you have a particular trademark, other person can be prevented by using that particular trademark even as a trade name. I might mean that the company name as it is. Other one is with regard to we call it as a comparative advertisement. Comparative advertisement in the sense that we can see that normally there are a lot of advertisement which may compare different products. Normally which we see that kind of advertisement in the automobile sector. Normally which we see. For example, we see a different comparison being done between the cars or something like that. Or different with regard to the torque or the speed or the length, size, power, etc. There is no problem with regard to that. But that comparative advertisement crosses, the boundary of comparative advertisement crosses to a particular level, wherein when we try to disparage the reputation of the one product, then actually it will be amounting to a trademark infringement under the Trademarks Act 1999. That is also a major change brought in by the Trademarks Act. So what happens in the comparative advertisement scenario? You might have seen there are a lot of cases, particularly between Hindustan Coca-Cola and Pepsi. Both sides, sometimes of using the Pepsi drink or the thumbs up, saying that they are all disparaging both each other, saying that this a bachon wala drink hai. You might have seen that. I'm not going to explain much further with regard to that. So that all being brought within the framework of trademark infringement under the Trademarks Act 1999. So why I say that, if you have a registered trademark and your trademark, you have a very wide provisions to protect you under the civil law as well as the criminal law itself. That is, criminal law itself, the main thing is that applying false trademarks or trade descriptions. That is a major thing. When other person simply duplicate your product or trying to copy or your descriptions, it will be amounting to, and it is a liability, criminal liability can be enforced. And with false description, the selling, that is, we say that the selling of products with a false trademark. will also amounting to the violation of Trademarks Act. And punishment is for a period of 6 months to 3 years. So similar like Copyright Act also. The same principle applies here also, like that. Can I just move to the next presentation, Vijita? Yeah. In the same manner, GI, Geographical Indications Act also there are provisions for criminal remedies, because when you have a GI registered in your, not in your name, because GI cannot be registered in an individual name. GI can be registered either in a community name or in a society's name, because it is a product or a trait of a quality of a product, or which is being natural or man-made, which is attributable to a particular place or a community. So that can only be owned by this GI, as you want. So just applying a false GI and selling goods or providing services to which the false GIs are applied. So that is also a criminal offense coming under the period of 50,000 to 3 lakhs. So you can see that these criminal remedies, apart from the GI, you can see similar provisions in the protection of semiconductor chip designs also. And but you cannot see the criminal remedies under the Patents Act. We don't have a criminal section, because Patents Act, it is, as you all know, that it is a very technically a police officer cannot cannot look into the aspect whether the patent, the other pirated version, or sorry, the infringed patent is already infringed, or in what aspect is being infringed. So the criminal remedies is not available to patent. Other all major things are being protected under the criminal remedies has been provided also. And one other important aspect when we discuss about, even though India do not have a statute for that, one is the protection of undisclosed information. Particularly, we have trade secrets, that we commonly say that trade secrets. And as you all know, the industry, particularly the software industry, it has been much used. Though India, there was a demand where you should have a specific statute for that. We don't have a specific statute to protect the trade secret as of now, but we are protecting under the normally either by the equity that is based on, for example, a relationship, an employer-employee relationship, master-servant relationship, which requires that the other secrets need to be protected, or by a contract, as you have an employee-employee. When you join a company, you have a specific contract to the effect that all the information, sometimes it may be customer information or a software source code, or other all databases which are kept in secret and by the particular company, proprietary information cannot be used by that. So that kind of situations also there is a violation of contract, or there is a provisions under the in Indian Penal Code, in which we say that criminal breach of trust, because you are, as an employee of an organization, you are being entrusted with certain informations which are under the belief that you should not exploit or utilize it against the interest of the company. When you utilize that, it is amounts into criminal breach of trust, and which is liable to be punished for an amount, particularly when you are employed up to a period of, even for a period of 10 years. So the gravity is more. So normally what we, in the practicing lawyers, when we come across these kind of situations, whenever an employee goes with a source code or try to incorporate that aspect, the Information Technology Act also comes into picture. There are provisions in Information Technology Act also which provides that the these kind of without permitting getting access to the computer database and using the database or taking copying out, all comes from the Information Technology Act, which also provides good penal consequences even up to a period of 5 years or more. So that is also liable, criminal liabilities are being provided. And when we come to administrative remedies, why do we say that it is administrative remedies? Is that administrative remedies are within the administrative system of each intellectual property office system. Actually. For example, I said in the beginning, if I have a copyright, or I am the copyright owner of a particular work, but I feel that I am the author of a particular story, but when I see that other person has been given registration for that particular work in his name, what is the remedy available? I can go to a copyright board to cancel that registration and grant it in favor of the other person. That is an administrative remedy available within the statute. Or in other manner, for example, there are provisions which provide in the Copyright Act with regard to the dispute, with regard to the assignments of copyright. When I assign, hope you understand what you mean assignment. Assignment is a mechanism through which the copyright is being transferred from one person to another person. It can be done in any manner. For example, I can split the right into any aspect I want. But I can split we have, as you all know, section 14 provides a list of bundle of exclusive rights. That bundle of exclusive rights I can separately transfer. Even the rights, each right I can also be split. For example, with regard to the right to translation of a book, I can give one right to translation Malayalam to another person. I can write to translate in Hindi to another person, or I can write to translate in English to other person if my work is in other language. So it can be split into any other part. These kind of can be done. And the same manner. So when there is dispute with regard to the assignments, or for example, assignment provides a provision, but even if after I'm doing an assignment, I'm transferring a right to make a cinematograph film to another person. A is transferring his right to make a cinematograph film to B. But B is not doing any step to exercise that right within a period of 1 year. So normally what happens is that assignment gets cancelled, but there is a scope for dispute. So such disputes can be decided by the Copyright Board. Actually, that is an administrative remedy provided under the Copyright Act. In the same manner, Trademarks Act also. In order to understand the administrative remedy under the Trademarks Act, you can go to I will explain the brief procedure of getting a trademark. You identify a mark, then you go for filing a trademark registration. You apply a trademark under the Trademarks Act. What the trademark registry will do that the trademark registry will make an examination of your trademark. The examination will be with regard to whether your trademark satisfy the criteria which is being provided under the Trademarks Act 1999. For example, whether it is distinctive. In order to understand whether it is distinctive, they will look into the aspect whether similar marks are already existing in the database, or whether this mark is already similar to a well-known mark. All these aspects will be, and they will be provided if they get you have a disappear similar mark in the database. What they will do is that they will give an examination report to you, and you need to answer that, reply to that examination report. For example, if you have a better claim, for example, the conflicting marks, as we normally say in the practice, the conflicting marks cited by the registry are used much after my use of my trademark, I have a better claim. Or if I say that the conflicting marks are not much deceptively similar, or the logo is different, or in manner in which it is presented is different, I can say that. And if in the case of with regard to the registrar is satisfied that my reply is satisfied, the registrar will publish the trademark in the trademark journal. Actually, the trademark journal it will publish in the trademark journal, and in the trademark journal, any other person, any third person, if I am the owner of the trademark, I feel that I might disappear similar, your mark and my mark is disappear similar, he can oppose the trademark under the Trademarks Act. So that is a provision. So that is called an administrative remedy available. I am the owner of a registered trademark, and other trademark which is disappear similar with me is being published in the trademark journal. I can oppose the trademark, say, being registered by the other party. So that is an opposition proceedings where I get an opportunity to how I oppose. I say that I have been using for this particular period, and I can provide all the details of the bills or the documents, etc. And I can provide with them the documents to show that I am the proprietor of the trademark, etc. Other person also can. The registrar will look into the aspect and he can decide whether my claim is genuine. The other person can block the registration of the conflicting mark actually. So that is also an administrative remedy available to a registered trademark. if in case, as I said, the example, if my mark I am going to, and the opposition, if I am able to overcome the opposition also, my mark is going to be registered under the Trademarks Act. So that is the thing. And even after the registration also, I feel that I can apply for a cancellation or rectification of the register, provided that sometimes I may be the owner of the trademark, but other person has applied for it. Then I can apply and apply for a cancellation of the registration either before the registrar or before the Intellectual Property Appellate Board. There is an Intellectual Property Appellate Board has been constituted under the Trademarks Act 1999. That is being operating in Chennai now. And what happening is that all the appeals from the decision of the registrar or these kind of things will go directly to Intellectual Property Appellate Board. And that is a remedy provided under the Intellectual Property, the Trademarks Act 1999. So, and when you come to the Designs Act also, this the cancellation and when a person is getting the design registration without satisfying the criteria, anybody interested can challenge the design registration. That is an administrative remedy provided to a person. That is also provided under the Designs Act also. When the Designs Act provides that your design should be novel, useful, it should be novel, and that criteria is not being satisfied, you can challenge the design registration under the Designs Act. So that is also, that is all actually, that is provided under all other acts also. For example, GI also, we have the semiconductor chip designs also. That is also, if the registration is provided without satisfying, or the registration is provided in an irregular manner, without correctly, the honors are not being identified, the registration can be challenged. So basically, these are the administrative remedies available under the different statutes actually. So encapsulating all these things, we have a civil remedies which we need to approach the civil code. We can see the temporary injunction, permanent injunction, and we can see the damages or accounts of profit, or we can see the seizure of the goods produced. And then you can see that when we come to the next step, when we have a criminal remedy, you can approach the judicial magistrate of the first class, or the police officer, not below the sub-inspector of police is vested with the power to seize and things provided under the Trademarks Act, and the Copyright Act is also being provided. There is no criminal remedy under the Patents Act, and administrative remedies are also being provided under the all sections, in which we have an opportunity to challenge if the registration is not proper, or the other person going to get registered is actually not doing it it is doing it in a irregular manner. We have an opportunity to challenge also. So here actually we are coming to an end. Vijita, can just move to the next presentation. Yeah, so we're coming to an end of the presentation which I planned. You are all free to ask any questions from in the field of intellectual property. There's no problem, particularly and the field of practicing. I'm a practicing lawyer in this field, so I'm expecting your all doubts with regard to that.
Vijita? Hello, Vijita, can you hear me?
Yeah. Can I answer questions posted by the chat room?
Yeah, sir. Vijita, hello?
Yeah. I will answer the first question. When you Muhammad Faris B, good question actually, Muhammad. When you say the design of a perfume bottle can be protected under the Designs Act, we have the shape trademark, will they both overlap? Exactly correct. Actually. That is correct actually. One question actually I do remember. When you say that Designs Act is being protected, the protection is given to the shape or any kind of ornamentation which you apply an article, it is coming under the Designs Act itself actually. And one important aspect is that the Trademarks Act 1999 has widened the scope of the trademarks and included the shape of goods within the purview of the trademarks also. So the question is very interesting actually. Under the Designs Act, you can apply for a design registration, and if you get a design registration, you get a period of protection only for a period of 15 years. But when you go for a trademark registration, if you get a registration, you get a period of protection for a period of unlimited period. So that is the advantage when you there truly they will overlap. That is the advantage of the providing under the Trademarks Act. But there is one risk is there with regard to the proving of a shape as a distinctive one before the Trademarks Act will not be that much easy when you compare with the getting a registration under the Designs Act. Because in the Designs Act, they look into the novel aspect, they look into the whether the novelty is correct with regard to the whether the particular design is with a particular product only. They wouldn't look into the other product. But when you come to the shape of a goods in relation to this particular class of goods, when you have to show that this is distinctive, in what manner it becomes distinctive, that also you need to show that. So there is clear a case of overlap, and there are people, it is actually we also practicing lawyers, we used to advise the clients, okay, there are opportunities before the Trademarks Act. But as I said earlier, there is a risk element is there. Risk element in the sense that in order to prove the distinctiveness under the Trademarks Act is not very easy as compared with the getting a design registration under the Designs Act. And yeah, Mohammed has asked another question also. Very good, Mohammed. Other question is also very good question. Does movie name get protection under the copyright law? There is a process of registering movie name under the film chamber. How this both differ? Yeah, that is very interesting. We are actually recently we are contesting a matter in respect of that. Truly speaking, purely a movie name or titles cannot be protected under copyright law. That is a principle. Mere titles cannot be protected under the copyright law. I'm saying that mere titles. Okay. But normally what we do is that normally what happened is that because there was the issue of Sholay. If you remember, there was a case in connection with the movie Sholay, where in which what happened is that you, after the release of the movie becomes so popular that you get the title gets connected to a person and it gets a reputation of its own. So normally the Copyright Act and the operation of the movie name goes beyond the copyright and it enters in the purview of passing off as well as Trademarks Act. I think Mohammed is hearing. Like Mohammed, is Mohammed there?
Yes, sir. Yes, sir.
Is Mohammed there?
Yes, sir. I'm
yeah,
here.
okay. I'm just asking. So what I was trying to say that mere Copyright Act will not get you a protection for the title names as it is. But as I said, when a movie is released and your movie becomes so popular, you are, you just go beyond that. You seek protection under the Trademarks Act as well as the, the passing of principle. That happens in the case of Sholay also. You can refer the case Sholay. The Bombay High Court has looked into that aspect. And another angle is that, but when there is a movie name along with it, screenplay along with totally, if you claim that it is totally different, you can make a claim under the Copyright Act. That is being copied, you can make a copy under that. That is another issue. And there is a process of registering copyright under the Film Chamber of Commerce that do not have a legal backing as it is. That is a, what to say that is a administrative mechanism followed by the Film Chamber to avoid the disputes as far as possible among themselves. Actually. So they say that I've registered this name, so I will get a priority over that. But if one person, other person goes with the movie, Film Chamber do not have any statutory mechanism to prevent other person from using that. What they can do is they can call for them and try to make an amicable settlement with regard to that. That is the only possible advantage of the registration. So I think Mohammed, is it clear?
Yes, sir. Yes, sir. Yes, sir.
Yes. The third question is that very good question. How the enforcement works in case of traditional knowledge, even though we don't have any separate laws. That is a good question actually. Traditional knowledge in India, particularly in India, traditional knowledge, we don't have a positive protection for the protection of traditional knowledge as it is. Because we are having a defensive protection. If you look into the statutes, for example, anybody who uses some traditional knowledge with regard to that, there is no, for example, if you look into the Section 3 of the Patents Act provides that any advancements which is made on the traditional knowledge cannot be patented. Section 3 provides that. And any person using the traditional knowledge makes that it is a ground for opposition of patent as well as rectification of patents. Okay, so that is a very important aspect. So we don't have a clear enforcement mechanism on trade. If other person has used any traditional knowledge with regard to that, to prevent that person. For example, there are a lot of cultural art forms in we have India. We have a diverse country. We have a lot of cultural art forms. There are a lot of IP researchers, particularly academicians, are working in instances in which these art forms, these color combinations, these are being used by the designers in other fields actually. So there are, as you all know, that we are all being with regard to these we try to protect and grant a remuneration. I'm not talking about Copyright Act, but regard to the Biodiversity Act, the Protection of Plant Varieties and Farmers' Rights Act, the Geographical Indications Act, the Patents Act. All these aspects actually are trying to provide some kind of protection to traditional knowledge. But I say that all are defensive protection. For example, I cannot. There are instances in which there is communities which came across and said that these are art forms, this picture have been copied by them, so they cannot do that. We have also filed a case against with regard to a traditional community variant. And fortunately, it was settled by making a royalty agreement between the community and the designers. With regard to that. So there are possible under the Copyright Act. All other forms, what I say that when a traditional knowledge is being used for making a patent or making an other product or other things like that, there are defensive protections are there available in the Patents Act. For example, in India, if you, Biodiversity Act specifically provides that you have to get the consent of the Biodiversity Authority, and then only you can use the traditional resources, biological resources, with regard to that. So there are other, as I said, that with regard to the protection of the Biodiversity Act, the Patents Act, with regard to, and also you know that Section 10 of the Patents Act provides that you need to, if you are using a biological resource, you need to show from where the origin of the biological resource. Also, you need to show that. And the Protection of Plant Varieties and Farmers' Rights Act also provides similar provisions where you are expected to show the origin of the plant variety if you are relying upon other variety from which you develop something else. So that kind of provisions are there. So, but I mean to say that they are not very positive in the sense, but they provide a defensive protection with regard to that. But as you are all academic people, one of the main challenges I feel is that, not only in India but across the globe, how does we collect a lot of funds for these purposes, but how do you find out the exact people who are owning this traditional knowledge? How do they share the benefit resources? How do they share? That is actually even my knowledge. World Intellectual Property Organization and other organizations are really working and conducted many workshops with regard to what is the best model of benefit arrangement or benefit sharing model with regard to the traditional community as well as those who want to develop that. Why I say that, if you look into the Convention of Biological Diversity, it is also we require sustainable use of biological resources also. We cannot simply close and our resources cannot be used by them at all, because that will not lead to a further development. We want to permit that. At the same time, we need to ensure that these people are equitably benefited by the sharing of the traditional knowledge as well as the traditional resources. Okay. Mohammed?
Yeah, sir.
Yeah, please. Other question also. Let me check. Mani Tyagi. Yeah, please. I'll just let me do that. Yeah, good question. Yeah, good question. That is, the question is like this. For example, can you claim a copyright on recipes? That is very good question actually. I think Mani Tyagi, do you mean by that? Can you just can you unmute her?
Yes, sir.
Yeah. What I mean is that a good question actually. Because they have created their own YouTube channel, cookery recipes are safe. Good question actually. So what is the protection we can get to a recipe? That is the important question. So if you have that is a difference between when you come to a principle of idea expression dichotomy in copyright actually. What is the expression? You are in copyright, you are getting a protection only on the expression. For example, if you have written a recipe book, nobody can reproduce that book, but you cannot prevent other person from using or making a sambar based on that particular recipe. Did you get my answer?
Yes, sir.
Okay, so that is, so there is no problem in, I may use any other person's recipe and I can make any other cookery shows I want. There is no problem in that. But
So
I
my,
cannot simply, yeah.
so my question was like in they are reproducing the same recipes and they are using it in their own YouTube channels. Like
Yeah,
they
exactly. They are not
YouTube
what
channels
they,
have been made. So what about that? There is no law who can
I
say
mean,
the
what I
same.
mean to say that, for example, I'm substantially copying the recipe and reproducing in the, I'm not saying that reproducing in the manner that exactly copying in the YouTube channel, that will be amounting to violation of copyright. But I cannot be prevented from making a particular thing based on that recipe and showing in the YouTube. You got it right.
Okay, okay, fine. Thank you.
Yeah, please.
Any further questions?
Yeah, please have the questions, please.
So you can unmute and pose your questions directly to the resource person.
I've answered the questions or posted. Dr.
Yeah,
Ratish?
I believe, sir. Yeah, sir, can you hear me, sir?
Yeah, I can, I can.
Yeah, so probably, sir, those are the only questions. I may request, I'll request Lakshmi Mena, research scholar at IUCIPRS, to kindly propose the vote of thanks. Sir, it was a wonderful session. I think
Good.
some of the facets that
Yeah.
you brought into picture, that is based on the practical aspects that you covered. So indeed an insightful session. So may I request Lakshmi Menon to kindly propose the vote of thanks.
Right, sir. Good morning, everyone. I have the privilege of proposing today's vote of thanks. On behalf of IUCIPRS, the organizers and participants of the FTP, let me extend a hearty vote of thanks to Binoy sir for being with us, for sharing his expertise as a legal practitioner.
Thank you very
Sir,
much.
you gave us, no, 1 second, sir, I have something more to say. Sir, you gave us a bird's eye view of all the different IPRs. You also explained IP infringement and legal remedies available for creators with clear examples. And I'm sure this will benefit all of us present today in understanding the practical nuances of IP enforcement. So thank you, sir, for sharing your time and knowledge with us. And I would like to thank all the participants for their lively engagements with the resource person. Thank you all. Thank you, sir.
Thank you very much. I am also really thankful to all the participants and Dr. Ratish and IUCIPRS and all persons organizers for giving me an opportunity, particularly through this online platform, to interact with you. And it is really a wonderful opportunity. Thank you very much. Thank you.
Thank you, sir. Just an announcement for the participants. So today we have the examination at 2 p.m. Which ends at 2:30 p.m. I've shared the instructions on WhatsApp as well as Google Group. We'll have the valedictory session and the feedback at 3 p.m. So request all of you to kindly join at 3 p.m. after the examination. So we'll meet again at